is the importance of paternal and paternal kin engagement and practical suggestions. We have two presenters for this particular section. First will be Milton Scott. Milton Scott is a program specialist for community-based programming at the National Fatherhood Initiative. He conducts training programs and provides technical assistance, promotes and supports national fatherhood initiatives. He has a degree in math and business administration and a master and an MBA from Harvard University. He's going to be presenting the first half of the program. The second half of the program is going to be presented by Davidson. He's been actively involved with legal aspects of child protection for over 35 years. He's been the director of the ABA Center on Children and Law since its establishment in 1978. He served as chair on the U.S. Advisory Board on Child Abuse and Neglect and is a founding board member of the National Center for Missing and Exploited Children. Mr. Davidson has various handouts here for some general reference, and he certainly invites everybody up to come and take whatever you feel might be helpful to you. I'm particularly happy that we're having a session on this myself. I've been very actively involved in Dodge County, primarily in Dodge County, helping fathers get involved in their cases. First appeal I ever did was representing a father in a guardianship case where the grandparents had abused the child and trying to make it so he could step in and take custody of the child. It was in Ray Sabrina K. The Supreme Court eventually decided that juvenile court always has jurisdiction, even if there's a guardianship, etc. It was an important case for establishing who steps in where, etc. But the father did eventually get custody of his daughter as a result and part of that, and have continued to be very motivated about getting fathers into the picture, making sure, as putting on a guardian ad litem, really pushing the county attorney and the Department of Health and Human Services to find those fathers right away, so that when we get to a point, if we get to a point of termination, we're not playing catch up on half of the case. So I think this is a really important issue and has really been served over the last several years, but I think clearly over the last couple of years we've been seeing a lot more emphasis and focus on this issue. So at this time I turn the floor over to Milton Scott.
Thank you very much. Appreciate the introduction and appreciate the opportunity to be back in the great state of Nebraska. I just mentioned that I had the privilege of living in Lincoln for a few months for a special training program that I was involved in a lot of years ago. And a few months in Lincoln in the fall was just wonderful. And I was able to, and I can say that I've seen the Nebraska State Fair in Lincoln. Something that people are not always going to be able to say in the future, I understand. And also, I'll just kind of throw into the hopper that I come from Western Pennsylvania. I flew out of Pittsburgh when I came to Nebraska yesterday. And in Western Pennsylvania, we take our football seriously. And I know there are some people in the great state of Nebraska who take football seriously. Not everyone, but some. And as a matter of fact, my next door neighbor played in Lincoln for a couple years and came back to Pennsylvania. So in Western Pennsylvania, if you say Nebraska, then everybody says, well, how's Big Red doing this year? And some years the answer is very easy. They're just rolling over everybody. But it somehow seems like, as I've watched the newspapers in recent years, you've got a lot more competition than you used to. I keep reading about schools in Missouri and Kansas and nearby places that are doing much better at football than they used to. At any rate, enough of the background, but it's really a privilege to be back with you in the great state of Nebraska. And it's a privilege to be with you as we talk about a very, very important topic related to the well-being of children in the state of Nebraska. Our hope this afternoon in our presentation will be to give you some general background information related to the topic of involving non-resident fathers, that is, fathers who are not in the home with the child, especially at the time of removal, and also some background information on the importance of dads in the lives of kids, wherever that connection is possible. And in Nebraska, there are a lot of good things happening in the direction of helping to engage non-resident fathers and reunite them with children, or at least help those dads and children have some aspect of their life together in common. So with that word of background, the label that we put on this presentation, as you see, is bringing back the dads, but then the more formal title is the importance of paternal and maternal kin engagement and some practical suggestions. Howard is the legal expert, and as you know from the introduction, he's the one who can answer all your questions about the legal side of things, and he'll be doing quite a bit in that area in this presentation. As a representative of the National Fatherhood Initiative, you might ask, Milt, why are you and Howard working together here? What's the connection here? Well, both Howard and I have the privilege of working with representatives from the American Humane Association. They now call it American Humane, but American Humane, on a joint project that's supported by the Children's Bureau at HHS, and it's called a Quality Improvement Center. And so I'll just give you a little bit more introduction to that as we move along. This is called the Quality Improvement Center, related to non-resident fathers, and American Humane is the principal investigator in this particular project. But Howard and his associates at the APA Center on Children and the Law are very, very much involved, and I'm very much involved together with some of my associates at the National Fatherhood Initiative. And as you can see, it's under a cooperative agreement with the Children's Bureau. The research question that's being asked in this Quality Improvement Center is, how is child well-being impacted when there is increased involvement by fathers and paternal relatives in the public child welfare system related to specific cases? The background of this QIC includes a report that was published in 2006 called What About the Dads? Could I just see a show of hands? Who has heard of What About the Dads? That was published in 2006. Very, very good. That particular study was done by the Urban Institute under contract with HHS. It's now being distributed by the Children's Bureau, and it was a very, very interesting study because they looked at approximately 2,000 children, 1,956 to be exact. They looked at approximately 2,000 children who had been removed from homes where the biological father was not present at the time of removal. And the project involved interviewing and looking at case records of 1,200 caseworkers who had worked with these 2,000 children. And as a result of looking at these case records, it was revealed that in 88% of the cases, the child had identified the father. The father wasn't there at the time of removal, but in 88% of the cases, the father was identified. In 55% of the cases, the agency had contact with the father. They managed to contact him. In 30% of those cases, the father visited the child. And in 28% of those cases, the father expressed interest in having custody or having the child live with him. And so this was the background, as I say, based on information from approximately 1,200 caseworkers. As a result of this study, the What About the Dads report recommended things that you're all very much aware of, even though you may not have read the 2006 report. The recommendations were that child welfare agencies should, number one, identify and search for non-resident fathers early in cases. Not at the end of the case. Early in cases. Why doesn't that search early in cases happen now? Well, there lots and lots of reasons, but that's part of the purpose of the work that we're doing, is to look at those questions. Number two, the recommendation was that caseworkers be trained on identifying, locating, and involving fathers. And number three, recommendation was that models be developed for engaging non-resident fathers constructively. So as a result of this 2006 report, what about the dads? There was some more work that was done in a follow-up report in 2008 called More About the Dads. And I'm going to not go through every detail of every one of these slides because you have it on your flash drive and you can take a look at it at your leisure. But in general, the 2008 report, More About the Dads, basically said when there is more involvement by fathers in paternal kin, generally speaking, good things happen. And some of the good things that tend to happen include that highly involved non-resident fathers' children exited foster care more quickly. And so the 2008 report revealed that when fathers were more actively involved in the cases, that placements happened in a smaller percentage of cases, and in a higher percentage of cases, paternal kin or the father were involved in the placement in some practical way. But for children who were in foster care, if their non-resident fathers were highly involved, they exited foster care more quickly. Across the United States, approximately 1/3 of children live in homes where the biological father is not present. And that percentage, or that proportion, varies by racial, cultural, geographic, economic factors in a great variety of ways. Also, consequences of father absence in the 1996 HHS report, now this is 10 years ago, or 13 years ago, and there have been numerous additional reports that have made similar points since. But according to the HHS report, children in single-parent homes, predominantly single-parent homes where the child lived with the mother, they had greater risks of being physically abused, being neglected, and the last line says, overall, 120% greater risk of some type of abuse. Additional consequences of father absence. In general, on average, youths from father-absent homes are more likely to experience poverty, emotional and behavioral problems, substance abuse issues, incarceration, and difficulty in their educational experiences. Benefits of father presence. There have been numerous studies that have been reviewed and reported in recent years that have talked about the costs of father absence and the benefit of father presence on average in the life of a child. Now, when I say on average, we all know of the cases that are exceptions to that average. But on average, there are significant benefits when the father is actively involved in the life of a child, and this is to some degree whether or not he's resident in the home where the child lives. Let me also mention that for most of you who came in, you got a booklet that looks like this. This is the father factor. And I would just encourage you to take a look at it at your leisure. But this particular booklet reviews with references studies that have been done that point out some of the benefits of father presence, some of the limitations of father absence in the life of a child. The QIC, the Quality Improvement Center, which, as I mentioned earlier, involves the American Bar Association, American Humane, and the National Fatherhood Initiative under the direction of the Children's Bureau. The QIC decided to look at the various steps that child welfare agencies go through in trying to engage fathers. And so we've taken a look at the task of identification. Who is the father? Can we find out who the father of this child is? What are the steps that we would go through in order to try to do that? Location. We may be able to identify him, but still not be able to locate him or communicate with him. So location is the next step. Actual contact is a subsequent step. And then finally, engagement. And the QIC is also looking at interagency collaboration. How can child welfare agencies collaborate with other agencies, governmental, social service agencies, nonprofit social service agencies, etc., in the community. And our process included going through some focus groups, doing some literature review, and I would say a number of the things that we discovered as we did that are things that you've encountered in your work. Dads have traditionally not been searched for, they've not been typically engaged greatly in the child welfare system because it takes more work. And it doesn't just take more work, it's sometimes complicated work that involves a lot of persistence on the part of the caseworker or on the part of the agency. And so, in a time when workloads are heavy, the very appealing approach is often to say, well, we know an awful lot about the situation related to this child, and so it looks like if we move ahead in the following way, we'll be doing what's in the best interests of the child, even though we may not have thoroughly explored the options on the father's side of the family or looking at paternal kin. And as we looked at interviews with focus groups and key informants, the general conclusion was that there's a lot being done that's very positive in the area of being able to identify and locate and contact dads. That is, these are all doable things when there are processes in place and when management works at making sure that those things happen. However, the actual engagement was seen to be the most difficult area. And so at the QIC, we've worked quite a bit on the engagement area, and I'll be finishing up in just a second, but let me mention that on the engagement side, we've been able to set up a process whereby there are 4 sites around the country that are working with a very specific research-oriented project. That is 4 sites that are doing research, targeted research for the QIC. And I made reference to the literature search. The 4 sub-grantee projects are in the states of Washington, Indiana, Colorado, and Texas. We have also developed a curriculum for use with groups of non-resident fathers that are working with the child welfare system. And as you look on your flash drives, you will see that there's an outline of the curriculum. Also then, let me mention that as you came in, you were also given a document that looks like this, that doesn't have a label on it, but it has a couple pages of introduction, and then if you glance through it, you'll see that there are about 120 different items that you can either check as applying to your organization or not. I'll give you the background on this. This particular tool is called the FuckFriendly Checkup for child welfare agencies and organizations. And the intent is, it's being experimented with at this point, is the way I would put it. But the intent is that this father-friendly checkup, which is targeted at trying to answer the question, how effective is my agency in proactively trying to reach out to and engage the fathers of the children that we're working with. And so this particular tool, 120 items, you can check if it's true of your organization or leave it blank if it's not. And these items fall into a number of different categories. The first set of items is leadership and organizational philosophy, and then, as you'll note, working through several different categories, including things like staff training and professional development, and the program physical environment, etc. And a few sample items in this thing that I'll just mention under the program management policies and procedures section. If you went through this looking at a child welfare agency, you can check whether or not the policies and procedures of my organization, quote, include a clear expectation that caseworkers and other staff will identify fathers early in child welfare cases and continue to attempt to identify them throughout the life of the case. Fairly comprehensive statement about identification. And if you go through this particular document, you'll see a total of about 120 items that you can use to kind of take stock of your organization. That particular tool is on the web. It's available on the website of the non-resident father QIC, and that web link address is www.fatherhoodqic.org. And you will notice that particular address 2 or 3 places throughout our PowerPoint presentation. And so I would encourage you to sometime take a look at fatherhoodqic.org and look at the welcome materials that are located there. At this point, I'm going to turn it over to Howard, who will be moving ahead with some other aspects of our presentation and generally speaking with more legal orientation in his presentation. So thank you very much.
I had the opportunity today to learn about a case from last year of the Nebraska Supreme Court. I guess I'm supposed to use this. Called the Amanda C. case. How many people are familiar with the Amanda C. case? And it's very relevant to this discussion. And it does something that I'm not aware of any state Supreme Court doing. Amanda was a child who, there had been in this family prior children who had been reported for abuse and neglect, and when Amanda was born, she was placed with the maternal grandfather and wife with the involvement of the child welfare agency. And ultimately, both parents relinquished custody, and the agency wanted the maternal grandmother, I believe, and her husband to adopt. But there was repeated interactions between the caseworker and the biological father about relinquishing his parental rights, which he ultimately did. Soon after he relinquished his parental rights, Amanda apparently her life went downhill, and she really deteriorated and got involved, I guess as a teenager at this point, after having been with the maternal grandmother for a period of time, went downhill. And when she became an adult, well, first of all, the father sued the worker in the case for actions that he believed interfered with his ability to maintain a relationship with his daughter. But then what's interesting about the Amanda C. case is then Amanda, as an adult, sued on her own behalf for alleging that the state had interfered with her relationship with her father. And the court, in a decision reported at 749 Northwest 2nd, 429, 2008, held that the case manager had violated her due process rights to a relationship with her father by continuously meeting with him and giving him legal advice, which of course workers are not supposed to do, regarding relinquishment after his attorney advised her to stop doing that. There are very few cases related to child welfare agencies and what they do or don't do related to non-custodial fathers. And in this case, it was a custodial, had been a custodial father. But what's significant is the Nebraska Supreme Court has recognized the importance of a child's relationship with her father, and given that due process constitutes, at least I guess under the Nebraska Constitution, separate recognition, not just the right of the father to contact with his daughter, but the daughter to contact with the father. So it raises some interesting issues in relation to what I'm going to talk about to the legal aspects of this engagement of non-custodial fathers when their children are in the child welfare system. Again, before you leave, please pick up these materials. How many of you are attorneys in the room? How many of you are workers or supervisors or public or private agency staff that are going to be, have been having, or will have contact with the non-custodial fathers in child welfare cases? Are there any people in the room who are lawyers who actually represent non-custodial fathers in dependents in court proceedings? We've got a few, very good. Well, one of the issues that I think is very, very important and which our center has been focusing on in this QIC project has been the quality of improving the quality of legal representation for non-custodial or non-resident fathers, as we refer to them. And we did a survey, and I won't go through this because, again, you have the slide in terms of how legal representation is provided. The Supreme Court of the United States actually has not said that it is a constitutional requirement in abuse and neglect cases generally to have court-appointed legal representation if a father or a mother can't afford legal representation. I assume in Nebraska that parents who cannot afford counsel are routinely appointed in abuse and neglect cases at the very outset of those cases, and that continues on through the process through termination of parental rights proceedings. This first slide is on how that representation gets done. We also found that counsel was often appointed late in the case rather than at the very onset of the case. That parents' attorneys often had high caseload, received minimal pay, and most importantly, for our work in the project, we learned that they had very little training, specifically on representing non-custodial parents. For those of you who do it, who represent the dads, as well as the moms, but who have represented the non-resident father, you know that there are a lot of tricky issues involved in this. And that is why, as you will hear, that we have published a series of articles, practice. We're coming out with a book. We're coming out with a training curriculum for lawyers that can be used in Nebraska and elsewhere. It's very clear that non-custodial fathers need legal representation, that fathers have to often perfect their rights based on Supreme Court precedents, particularly if they have not had an active involvement in the child's life. States vary in terms of the presumptions related to non-custodial father's ability to take custody of the child. There are systemic barriers and biases that I'm going to talk about, and I can't remember why FuckFriendly Checkup is on this slide actually, but I think you can take that FuckFriendly Checkup, and for those of you who are involved with the courts, see if see how it applies to the whole court process when fathers are involved in the proceedings. constitutionally protected interests of parents in raising their children is pretty clear, and here's a number of Supreme Court, earlier Supreme Court precedents in that respect. And there are cases that I haven't included on the slide, Stanley versus Illinois, and some others that have to do with the basic proposition that whether it's a mother or a father, unless they are proven unfit to care for a child, they have a presumptive right of custody of their child. Visitation could also be considered a constitutionally protected interest. Obviously, the application of the clear and convincing evidence standard before parental rights are terminated. The Supreme Court establishes but limits the non-custodial father's right to rear his child. And this is particularly in the case of unwed fathers, the need to demonstrate a full commitment to the responsibilities of parenthood, coming forward to participate in the rearing of their child, interest in personal contact with the child requires substantial protection under the Due Process Clause. At that point, it may be said that he acts as a father towards the children, but the mere existence of a biological link does not merit equivalent constitutional protection. There the Robinson case authored by Justice Stevens in 1983. So, as a result of that principle, non-custodial fathers often find themselves in the position of having to perfect their legal interest in the child to be entitled to notice and opportunity to be heard. We'll talk about the Foster Connections Act provision in a moment, but in terms of their constitutional right to notice and opportunity to be heard, obviously it is important for them to establish or attempt to establish a relationship with their child. That can be done in a variety of ways. For an unmarried father who is not married to the mother and whose name may or may not have been on the birth certificate, the putative father registry, name on the birth certificate, blood tests obviously, an affidavit of paternity or beginning paternity proceedings, and of course if they were married to the mother at the time of conception, there's actually a Supreme Court decision saying that of course there's a presumption that the non-custodial father is entitled to the full legal rights.
But he hasn't paid all his child support.
Well, it doesn't divest him entirely of his rights unless his parental rights have been terminated. Okay? And I think one of the issues, child support, is the elephant in the closet in this conversation, elephant in the room, and we will talk about that issue because the child support issue is often the main reason why the non-custodial fathers are fearful of coming forward and participating in the child welfare case for a variety of reasons. So perfecting the non-custodial father's legal interests takes time, money, and knowledge of the system. And even assuming the non-custodial father has perfected his legal right to his child, he still may not be afforded the full complement of constitutional protections custodial parents receive. Because states handle this issue in child welfare proceedings very differently. For example, let's take as a fundamental scenario that father and mother live apart, and mother has abused or neglected the child, thus resulting in the involvement, a report of child abuse and neglect, and the involvement of the state. And let's assume that the father has never had any involvement with Child Protective Services, has never been found to have abused, neglected a child, or to be unfit. Okay, so here we're dealing with a presumptively fit, non-offending, non-custodial father, and he wants custody. He doesn't want his child to be in foster care. He wants to take care, he wants to take responsibility for this child. Well, it's not so easy. In some states, it's very clear that the court and the agency can compel the non-custodial father to comply comply with services. He hasn't done anything to harm the child directly, certainly. The issue of whether he's failed to pay child support obviously has some bearing on the child's past living situation. But some courts and in some states, and we gave some examples here on the slide of states that have these different approaches, and you can tell me where Nebraska falls in this scenario, these three scenarios. One is we can take jurisdiction over the dad, the agency and the court, and compel him to comply with services if he wants to have contact with the child, including custody and unsupervised visitation. That's approach number one. Approach number two is the non-custodial father comes forward. In this situation, the court must give him custody. The mother can't have custody because she abused and neglected the child. Rather than the child go into foster care or with some relatives, father must get custody after the finding that he's unfit. But the court and the agency can still require that the non-custodial father comply with services. So this is a kind of a middle ground. You know, he has to get custody, but we can keep the case open, make sure that he's doing what he's supposed to be doing so the child will be safe. Okay? Approach number three. This is the most reflective of a father's constitutional rights. The court can't assume jurisdiction at all if there's a fit parent, regardless of the conduct of another. If one parent is unfit, the court can have jurisdiction over that unfit parent. But if there's another parent that is there, the court should, before dismissal, award custody, non-custodial father, enter findings against a custodial parent, and because the father hasn't done anything wrong, and why should there be state supervision over the father? Now, I'm not telling you which of these three approaches is best, which approach, and you tell me, does Nebraska fall into any of these three discrete categories?
We're about a 2.3.
Okay, it's somewhere between 2 and 3.
We're right in there.
Okay, all right. Because, you know, we often, and I don't know if I have it on the slide, talk about non-custodial fathers having to jump through hoops that legally we might not be entitled to make them jump through because they haven't been found, adjudicated to be unfit, to have abused or neglected their child by a civil court, by a criminal court for an act related to child endangerment or anything else. You had a comment, question?
Well, just essentially my understanding of what the court's position generally is that the adjudication goes to the child and not to the parent. And that in that reunification where it's the dispositional phase where the father gets an opportunity to sort of step up and the court has a lot of latitude in that regard.
Dispositional comes way down the pipe, doesn't it? Sometimes.
Sometimes, right.
Yeah, but we also have a rule that if we deny temporary custody, that's a final appealable order. And if the state has not established affirmatively that the father is unfit,
Right.
they get custody. We may keep jurisdiction, but they get custody right away.
So what are the barriers to fathers, non-custodial, or as we call it, preferably non-resident fathers, getting involved when their children go into foster care? Okay. The first is, and Milton has really talked about this, we have a child welfare system in America that is not terribly good at engaging men. Okay, that's what the FuckFriendly Checkup is all about, and that's what the What About Dads, What About the Dads report, and the follow-up more about the Dads report document really, really well. Okay, we don't do a good job. We're a maternal-centric system, and many of our caseworkers have had bad experiences with men. And many of the players in the process would just as soon not have to deal with the complexity and sometimes danger of dealing with the dad. Okay. Unfriendly, sometimes there's an outright bias towards dads. I'm not saying this occurs in all places, but it is a problem. There's also, how many people are in the room are from child support enforcement agencies? Nobody. Nobody probably at this conference is from a child support enforcement agency. There is an utter lack throughout the country of adequate interagency collaboration to locate the non-custodial fathers, or to use the child support agency as a vehicle to actually facilitate the father's involvement with his child. Good child support enforcement people will tell you that it's not just about collecting money. It's about improving paternal relationships with their children. And the QIC that we've been working on really has brought in child support enforcement people. As a matter of fact, the issue coming out of the newsletter for our project, the lead article is written by the new director of the Federal Office of Child Support Enforcement. A lack of policy and procedures to help identify, locate, and contact non-custodial fathers. If this work in Nebraska is being turned over to private agencies, they sure need to get up to speed in the latest science and knowledge about identifying, locating, and contacting non-custodial fathers, how to find them, how to talk to them, how to engage them in the process after they're found. And as I've said, there's often a worker reluctance to contact a non-custodial father, and a feeling that it makes the case overall more difficult when you're having to deal with the dad. We've learned this and heard this from around the country. And not on the slide is still another issue, legal issue that confounds us, which is the interstate compact for the placement of children, because dads often reside out of state. Okay. Now, my understanding is Nebraska legislature has passed the new ICPC. Does anybody know what I'm talking about when I talk about the new ICPC as distinguished from the old ICPC? Well, the Interstate Compact on the placement of children was modified by the American Public, the Secretariat, which is the American Public Human Services Association, and they developed a new version of the Interstate Compact on the placement of children because of criticism about the operation of the Interstate Compact, and I believe Nebraska is among the first states to do the new ICPC. The old ICPC had no exemption for dads coming forward from out of state in terms of having to go through the ICPC process. But the new ICPC actually has a process for exempting non-custodial parents from in out of state. First of all, there are three things that you have to show to not have to use the ICPC when the father is out of state. The first is the non-custodial father has to prove that they have a substantial relationship with the child. I'm not sure how that's defined. That is certainly going to be the task of the lawyer for the non-custodial father to help bring in evidence of that. Second is the court, in this case the Nebraska court, where the child may be sent to the father in another state, has to make a written finding that placement with the dad would not be contrary to the best interest of the child. And the third, and probably most difficult to swallow, will be the third requirement that in this case the Nebraska court has to then have the child, order that the child be placed with the father in the other state and then dismiss the case. Okay? Because it will dismiss the case involving the dad. If it's still an abuse and neglect case involving the mom, I don't think you have to, if you're keeping that open, you don't have to, I don't think you have to dismiss that. I'm not administering this new ICPC. It's the American Public Human Services Association, and you want to address your questions to them on this. But there is a process that has been put into the new ICPC for avoiding the need to go through the ICPC process with either mothers or fathers who reside out of state. because the ICPC really is replacement with non-appearance. That's fundamentally what the ICPC was about. And unfortunately, the old ICPC made it very, very cumbersome to place with a parent out of state, and the new ICPC at least sets some ground rules for that. Another big problem with getting non-custodial fathers involved is mothers as gatekeepers who are not coming forward with the information about the non-custodial father. She's keeping the information hidden. Sometimes she's keeping the information hidden about the non-custodial father at the request of the non-custodial father because he doesn't want to be slapped with child support orders. Or she may be protecting an informal under the tables agreement. Or she may have a good reason. She may be fearful of the father's involvement with her and the child because of past domestic violence. And as I mentioned this morning, domestic violence is actually listed as an exception in the Fostering Connections Act to that mandatory 30-day notice to relatives. It's unclear how states will, or the federal government will interpret the use of that exception. But domestic violence, there may be two elephants in the room in these cases. One is child support and the other is domestic violence. But states that have looked at this recognize that domestic violence exists on a continuum. And you can't treat all fathers in all situations where there has been any domestic violence the same way, with the exclusion or non-exclusion. You've got to look at the circumstance of each particular case. And of course, the last issue is the mother may simply not know the identity of the non-custodial father. So how can we better engage non-custodial fathers? Okay, we need to understand their basic legal rights. We have to identify them, locate them early. I don't know how this workshop got labeled under the permanency hearing. If you look at the title of this workshop, you see it's under permanency hearings. Please don't wait till permanency hearings to engage non-custodial fathers. You won't have learned Howard Davidson's lesson of the day, which is early, at the beginning, as early as possible. Get them lawyers as early as possible. You will be doing their children a favor. Okay? Address and understand non-custodial fathers' rights for visitation. Engage non-custodial fathers in case planning. Be aware of other issues. Just to further expand upon them, I think the slide lists constitutional rights that have been identified, have been recognized, that I've already kind of talked about the things on this slide. Early, failure to properly notify the non-resident father may violate his constitutional rights, and that it may delay court proceedings, result in a reversal of judicial findings regarding the father at hearings to which he was not properly notified, deprive the child of important paternal resources. You know, one of the reasons you get the father involved early on is not simply that the father may take custody of the child when needed, but that his relatives, his parents, you are going to miss an entire side of the family in terms of resources and support. And in fact, it may be through the paternal kin that you get the father more involved. It may be through his parents. Okay? Clearly, not involving the father early on is going to delay permanency. And you have a good law in the state of Nebraska, if I've got this right. It requires non-custodial parent notification. It requires non-custodial parent notification. So, how do you overcome the barriers of the mother as the gatekeeper not wanting to give information about the father? Asking your lawyer, if you're with the agency, asking your lawyer to examine the mother and family members under oath to get identifying information about the fathers. Put them under oath Threaten to hold them in contempt of court if they don't reveal that information about the dad. Request that the mother and her counsel file an affidavit concerning paternity. Request that the judge inquire at every hearing about the non-resident father's whereabouts until he is found. See if the non-resident father has other legal cases that will help you locate him. Domestic relations. Some of these fathers are easily found by just checking other court records. You know? And not on the slide is the importance of using, and something I've already mentioned, using child support enforcement resources in every case. How many people work for a child welfare agency or for a private provider that's going to be working with families? Raise your hands. Okay, please establish a working relationship with the child support enforcement agency to enlist their help. They have access, which technically you should have access as well, to something called the parent locator service. There are resources that are very sophisticated the child support enforcement agencies can use to find fathers, but they also have, and this is where we get into the elephant about child support enforcement, they also have the ability to make decisions about reducing child support orders, modifying them in ways that will encourage the father to come forward. Okay? Child support, again, as I said, good child support enforcement agencies are not just about collecting the money. They're about looking at ways, and a lot of these dads are in situations where they can't meet their child support obligations. And child support enforcement agencies increasingly are working with the dads around employment opportunities, vocational training. Think about ways that you can work with child support enforcement agencies as a partner in strengthening families. Think about that as a resource for you. Address the right to visit. Again, you can't overlook safety concerns, but again, lawyers for non-resident fathers should be requested liberal unsupervised visitation with the child. Help the father get to better know his child. Some fathers may have been absent for some time. Now the child is older and is more likely to want to engage with the dad. Okay? Engage in non-resident fathers in case planning. One of the things the CFSR process found is that not only weren't the moms being adequately engaged in case planning, but certainly the dads weren't being engaged, and probably whether they were resident or non-resident fathers. And so this slide has some ideas on how to address that. Again, you have this on your USB drive. As I said, be aware of other issues. What are the barriers that dads may face? Child support is certainly a big one. We have an article that you can pick up here in the July issue of our child law practice called Legal Strategies to Address Child Support Obligations for Non-Resident Fathers in the Child Welfare System. I think a very helpful article to deal with that issue. But fathers may have other concerns and reasons for being fearful of stepping forward. Criminal cases, domestic relations proceedings, immigration issues. If you represent, and again, there are only a few people in the room who actually represent the non-custodial fathers, but key strategies: challenge allegations of failure to protect or abandonment that may be barriers to a non-offending non-custodial parent assuming custody, if indeed he had no responsibility for the abuse and neglect that occurred. Contest, here's a good one that Judge Key would appreciate. Contest reasonable efforts findings related to preventing removal or in whether there were reasonable efforts to reunify the family. If the non-custodial father is not actively engaged in the process, how can there be reasonable efforts? Okay? Ensure court-approved case plans include non-resident fathers and their relatives with attainable appropriate goals. And for lawyers for the fathers, make sure their story gets told, what obstacles he's overcome. You know, a lot of these fathers have had additional children and are successfully and safely parenting other children. And sometimes that information doesn't get brought before the court. That not only is his father interested in taking more responsibility for these children who have been the subject of the abuse and neglect proceedings, but he's successfully taking care of other children now. And you know, that's an important factor for the court to know, to put the father in a more favorable light. Be aware of how other court cases impact the dependency case. I've already kind of talked about that. Be cognizant of service overload, but also knowledgeable about gender-appropriate services and those that can help him meet his case plan goals. Find services within your community, programs that know how to talk to fathers, to talk to men. And Milt's organization can help find those. They're out there. We're, through the QIC, developing, promoting some very interesting models of programs that work with men. And find the programs that work with men that may not work with the child welfare system. Try to get programs that deal with fathers and men to actually think about doing, for example, a support group for fathers with kids in the child welfare system. Okay? We are supporting work. How many weeks is it? It's a multi-week program. 12-week program, a structured program that we can provide you information on that can be modified, that can be modified in Nebraska for use as support groups with non-custodial dads that are designed specifically to work with men. If the non-resident father is not interested in assuming custody, make sure you get information about his family, find out whether they have an interest in the child who's in the system or children in the system. Help him understand the importance of court-ordered services, help him keep track of appointments. What does he think he needs to be more involved in his child's life? Ensure incarcerated non-custodial fathers get needed services. And remember that they're not always going to be incarcerated. And be sure to look at incarcerated dads over time. Don't just look at the fact at the beginning of the case that they're in prison, because they may be scheduled for release. They may have an opportunity later to come forward. Already said this, non-custodial fathers may seek custody visitation at any point. Here are the different points in the proceedings. So what are we going to do in closing at the ABA to help you at the Center of Criminal Law? First of all, we've commissioned, and there are a few examples of this up front, but we have a book coming out actually that puts all these things together, a series of practice and improvement articles. And here are a list of those articles. They're written by different people, experts, lawyers from around the country. We also have a training curriculum that we can make available for you in Nebraska that will be finalized very shortly. It's been field tested at several locales. And here are the elements of that. Here's a little bit more information on what the curriculum includes, a section on constitutional rights. A section on in-court advocacy. A section on out-of-court advocacy. And finally, and very importantly, a section on ethics of representing non-custodial fathers, written by my colleague Jennifer Rennie, who wrote a book on child welfare legal ethics, and who teaches legal ethics at Georgetown Law School. So that curriculum will be finalized shortly. The book will be out later this year. And I want to make sure that if you're interested in these materials, that you get them. There's an issue of the QIC Project newsletter where the title of the issue is Enhanced Representation for Non-Resident Fathers. Series of articles, materials about the QIC project, and I'll take some questions. Yes?
What do you do, quick question, what do you do if you have a child, a 14-year-old child, and a non-custodial resident father who wants visitation, who wants custody, but yet on the other hand, the child does not want visitation, does not want to live with it?
Well, she has a guardian ad litem or attorney to of course, and get that before the court, and as the reason why and all that, is that she is scared because of fear of harm, is there some other reason, is this an area where counseling could be useful, and so forth, particularly if there has been a long period of separation between the 14-year-old and her dad. There's no easy answer to that question, obviously. That's why the father needs a good lawyer, and why the 14-year-old's viewpoints need to be made known through their attorney or guardian ad litem. I don't have the answer to that. It's a tough question. Yes, any other questions? All right, well, thank you very much on behalf of Milton, myself, and our make sure you get the materials before you leave. There should be plenty for everyone.